So good afternoon to all of you. Bonjour. Je tiens d'abord à souligner que nous sommes réunis ici aujourd'hui sur le territoire traditionnel non cédé de la nation algonquine Anishinaabe. Thank you for being with us today. It is a great pleasure to join the Honorable Sean Fraser, Minister of Justice and Attorney General of Canada, and the Honorable Rechi Valdez, Minister of Women and Gender Equality, for this important announcement. We are also joined this morning and this afternoon by Honorable Ruby Saura, Secretary of State Combating Crime, and the Honorable Nathalie Provost, Secretary of State Nature. I also want to welcome some very special guests here today. Monique Saint-Germain, General Counsel with the Canadian Centre for Child Protection. Her role includes working closely with Crown attorneys across Canada to ensure victims of child sexual abuse material are heard in court, and the impact of online child exploitation is taken into consideration at the sentencing of offenders. And Nneka McGregor, co-founder and executive director of Women at the Center. She is an advocate who works with government and other organizations to eradicate violence against women. This is a good moment to note that the topics we are discussing could be very distressing. Please know that there is help available. We have officials in the room who can help you find resources or supports if you should need them. Today, our government introduced Bill C-16, the Protecting Victims Act, in Parliament. This is a significant step in our efforts to protect victims and survivors of sexual violence, gender-based violence, and intimate partner violence, and to keep our kids safe from predators. Dans un monde meilleur, nous n'aurions pas à nous réunir ici pour discuter des crimes atroces, tels que la violence motivée par le contrôle et la peur qui touchent principalement les femmes, les incidents traumatisants et perturbants liés aux infractions d'ordre sexuel commises contre des enfants, et les victimes et les personnes survivantes qui se sentent dépassées et revictimisées par le système de justice. In a better world, we would not have to stand here and talk about horrific crimes such as violence driven by control and fear that overwhelmingly targets women, traumatic and disturbing incidents of child sexual offenses, and victims and survivors who feel overwhelmed and re-victimized in the justice system. Tragically, this is our reality. These issues impact people in every community, in every corner of the country. But we know that change is possible, and we must come with a collective effort from all levels of government and civil society. À l'approche de la fin des 16 jours d'activisme contre la violence fondée sur le sexe, il est important de réaffirmer notre engagement à dénoncer la violence sur toutes ses formes et à l'encontre de toutes les personnes. As we near the end of the 16 days of activism against gender-based violence, we must recommit ourselves to speaking out against violence in all its forms against all people. That speaks to the need for legislation such as Protecting Victims Act, which would help save lives, prevent heinous crimes, and ensure that every family in Canada is kept safe. But before we talk about what the bill would do, it is important to hear about why these changes are so critical and so urgently needed. On that, I ask you to please help me welcome our first speaker, Monique Saint-Germain. Monique.
Thank you, Minister Fraser, and everyone in government for inviting us today. My name is Monique Saint-Germain, and I am General Counsel for the Canadian Centre for Child Protection. As an organization dedicated to protecting children from online harms, we are at a pivotal moment in this fight. For more than 2 decades, our agency has operated cybertip.ca, our national tip line for reporting online crimes against children. What we are seeing today is unlike anything we have faced before. Reports of online sexual luring targeting Canadian children have surged to unprecedented levels. Last year alone, cybertip.ca received over 2,700 reports of child luring. That represents an increase of more than 800% over the past 5 years. These numbers are not just statistics. They represent real children, real families, and real harms. But this isn't a simple problem. It is complex and it's serious. It intersects with broader issues like sextortion, gender Online spaces means that our policy responses need to adapt just as quickly. This is why today's announcement really matters. It shows that the federal government is prepared to take action to protect our most vulnerable. We welcome the amendments to the criminal code that aim to strengthen online child protection because they send a clear signal to everyone that the safety of children online is a national priority. For example, the new offense of threats to distribute child sexual abuse material are welcome. The increase or the expansion of the availability of protection and prohibition orders for those up to age 18 under section 161.1 and 810.1 are also very welcome. The criminalization of deepfakes for non-consensual distribution of intimate images and the strengthening of the federal mandatory reporting law will all help to assist in bringing criminals to justice. At the same time, we know that this is only the beginning. While today's announcement is a very important step forward, more must be done. That includes stronger regulation of online spaces with clear guardrails and accountability for online platforms. Through these comprehensive measures, together we can ensure that survivors of child sexual abuse know we are here for them and that they do not have to continue this fight by themselves. We look forward to continuing to work with the Government of Canada to safeguard children and youth from coast to coast. Thank you very much.
And now I'd like to invite Ms. Neka McGregor to share a few words with you.
Thank you very much. Thank you, Minister Fraser. Thank you, Minister Valdez, for inviting me to say a few words to everyone today. As mentioned, my name is Neka McGregor, and I am a survivor of attempted intimate femicide. I'm also the co-founder of a very unique organisation that was created in 2008 by and for survivors of all forms of gender-based violence. We've been advocating for ages for the types of changes that have been introduced today. And I'm really, really grateful to Minister Fraser, Mr. Valdez, for actively listening to the calls from survivors. I want you to imagine waking up on January 1st, 2026, to news that 187 women and girls have been brutally murdered by a gang of men. Imagine the shock and the outrage and the urgent calls for real action to be taken to address this lethal form of gender-based violence. This is precisely what happened in 2024, but those killings didn't happen in one day. They were spread out over a series of days, weeks, and months. That fact that 187 women were killed was spread over a 12-month period in 2024, I think has lulled many into a false and dangerous sense of ease and security, because society at large thinks that these are isolated incidents and not part of a pattern of gender and social injustices that continues to position women and girls as disposable. You think you can guarantee that this can never happen to a woman or girl in your life, because somehow the women and girls in your lives are insulated from this type of violence. The sad truth is that they are not. None of us are. This past weekend was the National Day of Remembrance and Action on Violence Against Women, and we gathered in public and in private to honour the memory of 14 women murdered at the École Polytechnique on December 6, 1989. That single event shifted the Canadian psyche in so many ways, but not sufficiently to end these types of killings of women and girls. And I want to share with you very quickly a couple of stats that will help everybody understand what is at stake. So last year, the 187 women that I mentioned were violently killed in this country. This year, we're currently at 137, and we've still got 3 weeks to go. So we know that that number will increase. In the overwhelming majority of cases in 2024, in 93% of instances where the perpetrator was identified, he was male, meaning that a woman and girl is killed every 2 days in this country, and most often by a man or a boy that she knows. Half of these women were killed by a current or former intimate partner, and 28% were killed by another family member. 77% were killed in a private location, such as their home, where we all expect that we're going to be safe. I want you to consider the righteous indignation we still feel about what happened to those 14 young women 36 years ago, and how easy it feels to skip to the next news cycle each time another femicide happens. I think it's because society sees these killings as single incidents. They are not. They are deliberate, they are gendered, and they are absolutely preventable. As one of the expert members of the Canadian Femicide Observatory for Justice and Accountability, under the leadership of Dr. Myrna Dawson, we have been tracking femicides in Canada since 2018. Marlene Ham and her team at the Ontario Association of Interval and Transition Houses have been tracking femicides in Ontario. Myself, Myrna Dawson, and other activists like Megan Walker, and most importantly, family members of other femicide victims, have been raising awareness of the hate-motivated killings of women and girls, primarily by men and boys, in the Canadian context. Many of us have been advocating for the types of changes to the criminal code similar to what's been tabled under Bill C-16, including adding the term femicide, because we want everyone to understand how and why these killings are different from other killings, and to highlight it as the national epidemic that it really is. I see this move as a really important education and awareness-raising strategy, and it's a step in the right direction. In the last 2 years, in the 2 years I was in the Ontario Domestic Violence Death Review Committee, and as founder of the Black Femicide Canada Council, I still see the systemic, social, and economic drivers that make it difficult for women to leave abusive relationships, but also recognize that leaving does not mean that the abuse will stop. At my organization, which is By and For Survivors, we know that criminalization of behavior by itself does not equate to or result in the end of that behavior. In fact, we've seen from similar legislation like dual charging, how criminalization can have unintended consequences that end up harming survivors, especially those who are Indigenous, Black, living with a disability, living in rural communities, and others who are marginalized. I know I only had 3 minutes. Okay, I will. This is why we welcome the addition of language of femicide to the criminal code, and will continue to work with the government to ensure that it is making generational financial investments into prevention, enhanced social supports, including safe and affordable housing, and training for legal system professionals, including police, judges, and everybody within the system. I'm going to move very quickly to the other area that I want to focus on, which is on coercive and controlling behaviors. As with femicide, the matter of coercive and controlling behaviors is not well understood by most in society. Unless the violence is physical or sexual, unless it leaves a mark or is backed by irrefutable evidence, and even then, it's not taken seriously across the board. But we, the survivors, we know, our children know, and agencies that have been supporting survivors know. Those who have experienced intimate partner violence have been saying for decades that the pattern of emotional, psychological, economic, and verbal abuse and threats of violence we experience are often as dangerous as the kicks, the punches, the hits to the head, the strangulation, and are also risk factors for femicide. Similar to the concerns I have about naming femicide in the criminal code, there are some in the gender-based violence sector who are skeptical as to whether criminalizing coercive control will actually lead to a reduction or eradication of male violence against women. I too share these concerns, but I honestly believe that the steps proposed today are steps in the right direction. I want to end by saying that I am an anti-carceral abolitionist feminist. I'm a card-carrying member of that group. And yet I still believe that the changes that Bill C-16, they are sound changes, especially given that I will continue to work with government and my colleagues in the gender-based violence sector to ensure that implementation of these changes do not result in more violence and unintended consequences. These changes in the law in general are just tools in society's toolbox to use in disrupting the generational male-perpetrated violence against women and girls in gender-diverse and trans communities, and other men, by the way. The government's generational budget 25, and it's using generational language for the changes here. But we plan to make sure that the government continues with generational support to address the generational trauma that many survivors and our families have endured. I want to thank Minister Fraser again and Minister Valdez for actively listening, hearing us, and championing our voices and our work within government.
Thank you, Monique and NECA, for your presence here today. And now I would invite Secretary of State Provost to address a few words.
C'est un honneur, un privilège d'être vivante devant vous aujourd'hui. Vraiment. Quel témoignage. Merci infiniment. Il y a plus de 36 ans, le 6 décembre 1989, j'ai vécu un féminicide. En fait, on l'a appelé tuerie très, très longtemps avant qu'on soit capable de nommer clairement ce que c'était. Moi, je le savais depuis longtemps. C'était que des femmes qui étaient mortes à Polytechnique. Mais ça nous a pris 30 ans au Québec pour être capable de dire c'est un féminicide et de changer la plaque commémorative pour nommer les choses telles qu'elles sont. Plusieurs d'entre nous ont été blessés, troublés, perturbés une longue vie. Mais j'ai toujours dit que j'ai vécu un drame exceptionnel. Il y a les drames ordinaires qui sont décrits avec beaucoup de précision et de talent et d'importance. Et c'est vers ça qu'on s'en va aujourd'hui. Moi, j'ai compris dans ma chair ce que signifie être visée simplement parce qu'on est une femme. Et ce féminicide a marqué ma vie. Il a marqué le Québec, mais il a aussi profondément marqué le Canada. Depuis ce jour, je sais qu'on ne peut lutter contre la violence qu'en la nommant clairement, avec précision. Et donc, aujourd'hui, cette réforme du Code criminel, merci infiniment, Sean, merci, Richie. Aujourd'hui, cette réforme du Code criminel montre que le Canada est prêt à affronter des réalités qui ont trop longtemps précédé la loi. En reconnaissant les violences basées sur le sexe et en inscrivant les féminicides dans le Code criminel, nous poursuivons enfin un travail essentiel de rattrapage et de justice. Le féminicide de Polytechnique nous a profondément marqués. Les années qui ont suivi nous ont permis collectivement de mieux comprendre ce qui s'est produit et d'en mesurer toute la portée. Encore aujourd'hui, c'est notre réaction, notre volonté de bâtir une société plus égalitaire et plus sécuritaire qui écrit la suite. Les changements que nous annonçons sont un engagement clair envers un avenir où aucune femme ne sera jamais visée parce qu'elle est une femme. Women who are killed simply because they are women do not vanish into silence. They become part of a long and painful history shaped by discrimination and hatred. We saw this at Polytechnique. And by legally recognizing femicide, we refuse to allow this violence to be minimized or pushed in the shadows. Nommer les féminicides, c'est reconnaître la réalité des femmes sont tuées parce qu'elles sont des femmes. Et ces crimes doivent être traités en considérant toute la gravité qu'ils comportent. Cette décision marque tout le chemin parcouru depuis la mort de mes consoeurs à Polytechnique et je suis très, très fière de faire partie du gouvernement qui vous propose cette décision. Merci.
Merci, Nathalie. Donc, la loi visant à protéger les victimes propose des réformes de grande envergure qui nous aideront à atteindre l'objectif que la loi, du projet de loi C-16 vise. Et sur ce, je voudrais tout simplement rajouter que nous allons obtenir cet objectif. It is clear that more must be done to build a safer world for all women and children and people of all genders. And the Protecting Victims Act, C-16, proposes sweeping reforms that will help us get to that better future. Now let me turn it over to Ministers Valdez and Fraser to tell us more about the legislation. Minister Valdez and Minister Sean. Fraser, the floor is yours.
Good afternoon, everyone. Thank you so much, Parliamentary Secretary Patricia Latanzio, for that introduction. And I'm so glad to be here with Minister Sean Fraser. We also have Minister Rebecca Chartrand, Minister Lena Mitlich-Diab, Minister Gary Ananda Sandagri, Secretary of State Nathalie Provost, Stephen Fuhr, and Ruby Sahota, and many of our incredible colleagues as well who are right behind me, including Parliamentary Secretary Marie-Gabrielle Mechnard, MP Linda Lapointe. And I just want to say thank you so much to the individuals who came earlier to speak. We have Neka McGregor from Women at the Center and Monique Saint-Germain of C3P Advocates and Community Partners. I want to say thank you for sharing your stories, very, very personal, which really set the stage for this very important announcement today. As we near the end of this year's 16 days of activism against gender-based violence, we are reminded that gender-based violence, as you've heard, impacts families in every corner of Canada, every community, and every walk of life. It disproportionately impacts Indigenous women and girls, racialized individuals, and to us LGBTQI+ Canadians. Every 48 hours, a woman or girl in Canada is killed in an act of gender-based violence. It is happening around us, around all of you. To people we know, in communities that we care about. And that is why today's announcement really matters. For women and survivors, I'm joined by a few, and for all Canadians who want our homes, our communities, and our country to be places where people can live in safety and dignity. Preventing and ending gender-based violence takes more than a single program or policy. It requires coordinated action across all levels of government, communities, and partners. Prévenir et éliminer les violences fondées sur le sexe demande bien plus qu'un seul programme ou qu'une seule politique. Cela exige une action concertée du gouvernement, des communautés, et de nos partenaires. Since Canadians placed their trust in our new government 7 months ago, we have been committed and provided over $250 million of new funding to support organizations across the country to prevent and address gender-based violence and support survivors. We are investing $1 billion in transitional housing, which will give women who are fleeing violence a safe place to rebuild their lives with their families. We are strengthening bail laws to ensure that serious sexual offenders serve their sentences in custody and not in the same communities as survivors. We are working with banks and institutions to identify, prevent, and respond to economic abuse because we know gender-based violence is not just physical. It is emotional and it is psychological. You heard it from Neka earlier already. All of these efforts work together to improve the safety of women and girls, but when violence happens, when someone seeks protection or when family is grieving, our justice system must be equipped to respond clearly, firmly, and with urgency. Notre système de justice doit être capable de répondre à la violence fondée sur le sexe avec clarté, fermeté, et urgence. That is what today's new legislation delivers for Canadians. It begins with clear and necessary of a shift. We are making homicide motivated by hate, first-degree murder, including femicide. This change directly addresses what families, advocates, survivors have told me and who have recognized for years that murdering women because we are women is a distinct form of gender-based violence. We are making the law affirm the seriousness of this violence and the need for the strongest legal consequences. And we're addressing femicide, which also means understanding what actually causes it. Violence in intimate relations often begin, you've heard it already, with control, with threats, with manipulation, and the steady erosion of someone's freedom and someone's safety. These behaviors are dangerous, and they can escalate long before an assault actually takes place and before it's reported to the police. So by introducing a new offense to criminalize these types of coercive control, we are enabling intervention. That is what we need. We need interventions so that it can prevent harm before it becomes irreversible, before more lives are lost in this country. And in a world where technology, we know what it's like out there, when it can be turned into a weapon, this legislation protects women from sexual deepfakes and the non-consensual distribution or threatened distribution of intimate images. No woman should have to have her identity or her privacy violated as a tool of abuse, period. And finally, this bill addresses a painful reality too many survivors and victims' families face, which are court delays. It should not take years for a case to move forward. Every delay can cause, and to so many survivors, re-trigger trauma. I've heard it from so many who've shared their stories with me. Every postponement forces those survivors to return to the memories that they're actually trying to heal from. And this legislation gives courts clearer guidance on managing those delays, which then strengthens the supports available to survivors throughout the entire judicial process. We've listened, we've heard you, and these changes are what you've asked for. Aujourd'hui, nous présentons un projet de loi qui reconnaît le féminicide comme meurtre en premier degré, qui intègre la violence coercitive dans le système de justice et qui renforce la protection contre le harcèlement criminel, les deepfakes et la diffusion d'images intimes sans consentement. Il donne aussi aux tribunaux de meilleurs outils pour réduire le délai judiciaire et réduire les traumas de survivantes. This legislation is part of our broader efforts to address gender-based violence at its root. It's a major, necessary step forward, one that actually responds directly to what survivors, frontline workers, and advocates have told us. By strengthening the justice system's ability to protect us, women and girls, we are building on our cross-government efforts to prevent gender-based violence, to support the survivors who need help, and to build a safer Canada for everyone. So to every woman, girl, and survivor listening today, your safety matters to us, your dignity matters to us, and your courage and your voices continue to guide our work. We will keep going, working with frontline organizations, with communities, and with all of you to build a future where every woman and every girl and every gender diverse person can live safely in their home, in their communities, and in this country. So I thank you all for being here. Merci.
Merci à tout le monde pour vos discours et pour être ici aujourd'hui aussi. Avant de commencer, je veux remercier mes collègues pour leur contribution de ce projet de loi. Premièrement, ma secrétaire parlementaire pour assurer les perspectives de la partie prenante à informer le projet de loi. Ministre Valdez, pour votre travail pour soutenir des organisations qui travaillent pour lutter contre les violences contre les femmes dans nos communautés. Et en particulier, Madame Provost, pour votre travail avant politique. Mais dans la fin de semaine passée, quand je rejoins la communauté dans ma circonscription pour organiser l'anniversaire de l'école polytechnique, vous êtes dans mes pensées. Un grand merci pour contribuer votre talent de nos politiques. C'est pour le bénéfice de le pays dans chaque région. Thank you as well to our guests for coming and sharing their perspectives on what this legislation means to help create safer environments for our children and to better respond to violence against women in this country. Over the course of the past number of months, it's clear that public safety has become a major priority for the Government of Canada. And of course, that responds to the fact that public safety is a major priority for Canadians. We've developed an approach that seeks to address very real concerns people have about safety in their communities by ensuring we adopt stronger criminal laws at the same time that we make investments at the front line, whether that's law enforcement, officers at the border, or the community organizations that are doing good work in our communities. And of course, if we want to end violence and crime in the long term, we need to make the upstream investments in affordable housing and mental health and addictions and in programs that address at-risk youth. But today we're talking about that first pillar, stronger criminal laws. This is not the first piece of criminal legislation reform that you will have seen tabled in the House of Commons. We have seen different pieces of legislation to strengthen our borders, to amend the bail and sentencing regimes that exist in Canada, to combat hate crimes that take place in the country. And of course, today, with the tabling of the Protecting Victims Act, we have an opportunity to better protect kids who are at risk of exploitation and to address very real concerns about violence against women, including violence that could be fatal. The first piece of the legislation that I'd like to draw into focus really touches on violence that we see that often plays out in an intimate partner violence context. You've heard multiple speakers share the statistic about a woman being killed in this country every other day. This is a statistic that should shock the conscience of every Canadian, not just because of the number of people who are impacted, but because we understand through our own experiences that these are real people in real communities. For some of us, that's the classmates that we grew up with, who we used to visit, who grew up down the street. For others, it is our coworkers who we no longer see at the office. And for others, it is the immediate family members whose life has been ended too soon. We are moving forward with changes that will recognize the severe impact that femicide has on families, on communities, on people in this country. We specifically will be creating a constructive first-degree murder charge where certain factors are present when a murder takes place, including a murder that is motivated by hate, including murder that takes place during the commission of a sexual offense, and including murder that follows a pattern of coercive and controlling behavior. I want to pause on this last point, because as you've heard, we've also made the decision to move forward with a standalone offense of coercive control. And in addition to the many advocates that you see here in our caucus, with community organizations and across the country, we owe a debt of gratitude to our former colleague in Parliament, Laurel Collins, who did incredible work in the last Parliament to advance this matter. And Laurel, if you're watching today, I want to say thank you and recognize your work in getting us to this piece of legislation. What's important when it comes to coercive control? We have an opportunity to have the justice system intervene, not just after someone has been killed, but we have an opportunity to have the justice system intervene before a relationship becomes violent and before violence becomes fatal. It is not enough to simply punish bad actors on the back end of a tragedy, but to do everything we can to prevent violence from taking place in the first instance. In addition to these changes that tackle matters of gender-based and intimate partner violence, there are new sexual offenses that have been established, including making good on the campaign commitment to criminalize the non-consensual distribution of intimate images, including specifically those that are created through the use of artificial intelligence. Il est essentiel pour lutter contre la violence et recogniser les changements technologiques qui existent maintenant dans nos sociétés. quand une personne partage les images intimes, c'est un crime absolument. Mais nous avons besoin de changer de règles pour recogniser les lois aujourd'hui n'incluant pas la recognition de l'intelligence artificielle pour ces raisons. It's essential in a world that we live in when we know we all walk around with phones in our pockets that are incredibly powerful, that create access to artificial intelligence, modern tools that certainly have benefits for society, that we recognize at the same time it creates potential for abuse. We are seeing a gap that exists in the criminal code, and we are fixing that today to ensure that artificial intelligence deepfakes will be recognized when it comes to charging people for the non-consensual disclosure of intimate images. Similarly, we'll be expanding the application of this particular provision to include circumstances not only where these images are distributed, but where their distribution is threatened to prevent that kind of sexual coercion from taking place in our communities. Along a similar line, it's essential that we adopt measures that better keep our children safe, who increasingly are growing up in an online environment in a world where the difference between the real world and online environments is indivisible. We are going to ensure that the threatening distribution of child sexual abuse and exploitation material is included to address challenges we see with sextortion in this country. We'll be establishing new offenses to better protect our kids, including inviting exposure of a child to an adult, and strengthening the ability of the Canadian justice system to respond to the abuse of children that may take place in another part of the world. It's important that we get these offenses right, but we also have to have a discussion about what the appropriate penalties are. There's a series of sexual offenses that will see higher maximum penalties as a result of this legislation, and at the same time, we will be following the guidance of the Supreme Court of Canada to restore mandatory minimum penalties in a way that is constitutionally compliant. This will have the impact not only of addressing the case that you will all be familiar with that recently came to light this fall in the Senville decision, which struck down the mandatory minimum penalty of 1 year for its unconstitutional status. But this should not come as a surprise. There are many instances where the Supreme Court of Canada has struck down similar penalties that existed in the criminal code. We're moving forward with a strategy that will not only restore those penalties that have been struck down, but that will protect the remaining mandatory minimums that have not yet been struck down, but which are constitutionally vulnerable. As we move forward, it's essential that we address some of the systemic challenges that are leading to cases being dismissed, not as a result of charges being defeated in a court, but as a result of delays. Les délais, c'est inacceptable. Ce n'est pas une bonne chose pour les victimes. Ce n'est pas une bonne chose pour la société. Nous avons besoin d'adresser ces défis dans le système de justice. After the Jordan decision a number of years ago, we've seen through recent reports nearly 10,000 cases have been thrown out as a result of delays in the justice system. We want to address this problem in a few different ways. We will be advancing measures within federal jurisdiction to speed up the process of criminal justice in Canada, including in specific amendments that will have an impact on sexual assault trials in this country. In particular, we will be changing the regime on how evidence is adduced to streamline the process and shorten the time between a charge and the conclusion of a trial. In addition to these procedural changes that will reduce the number of cases that face lengthy delays, we will be addressing, in the short term, the phenomenon where cases are dismissed for delay, again, not because charges have been defeated, but because the process has taken too long. We intend to do this by specifically dealing with the way that time is calculated, by scoping out certain kinds of applications from the calculation of time, by better clarifying when a case is complex for the purpose of the definition in the Jordan decision to ensure that those which are likely to take longer, potentially including many sexual assault trials, will less often be tied to the lower temporal threshold set by the Supreme Court. And we will be asking the court specifically to consider remedies other than a stay of proceedings, because I can tell you it does not feel like justice to survivors of sexual violence when at the end of the process there is no conviction and a perpetrator, despite not defeating the charges, continues to live in the same community and in some instances the same neighborhood as the victim. We'll be moving forward with certain amendments to the Victims' Bill of Rights as well to ensure that victims have a role to play, that they have information about where they can play a role, and that their voice will inform the judicial process when they're going through the criminal justice proceedings. There is much work ahead. The criminal justice reforms that we are putting on the table today are an important step in the right direction. But I would be remiss if I didn't recognize the extraordinary need to continue to support survivors in communities and the organizations that work with them to advocate for change and to provide meaningful supports. For too long, gender-based violence has been treated as a women's issue. We've been counting on survivors to be their own advocates and leaving the hard work to community organizations who work professionally in this space. Gender-based violence and the exploitation of Canadian children is an issue that should concern all of us. And I hope that you will take from today that the federal government is committed to being a good partner in this cause, and we look forward to receiving the support of all parties in the House of Commons to adopt this bill expeditiously. Thank you, and grand merci.
Thank you to both ministers, Fraser and Valdez. So now we will now move into the question and answer period. If you have your questions, I would invite you to come closer to the mic, and I think Lola, you'll moderate.
Yes. Hi, one question, one follow-up. Please state your name and outlet.
Hi, it's Stephanie Taylor with the National Post. This question is for the minister. It's about Bill C9. I'd like to know why are government MPs going to be supporting the amendment from the Bloc to remove religious defenses from the willful promotion of hate in the criminal code when the government has heard loudly from Muslim and Christian and other religious groups that this could insert uncertainty into their teaching and preachings of religious texts and potentially chill their speech?
Thank you. And look, I will address the question head on. I do think it's important that we reflect on the reason we're here today to address a piece of legislation targeting gender-based violence, but I appreciate there are multiple priorities, all of which are important. So let's be clear about what's being proposed and what's not. The amendment that the Bloc is proposing will, in my view, in no way, shape, or form prevent a religious leader from reading their religious texts. It will not criminalize faith, and to suggest otherwise, in my view, is a perversion of the values that the major religions in this country and around the world stand for. Somebody who grew up in the Catholic Church and read Scripture on Sundays my whole life, I can tell you that I don't remember any messages about religion telling you to hate thy neighbor. We are dealing with charges that touch on the willful promotion of hate. That is not a value that the world's major religions stand for, nor would I accept such a change. We've engaged with a number of parliamentary colleagues, including the Bloc members who are seeking to put forward this motion, including members of our own caucus, including on a number of occasions members of different party caucuses. What's important to recognize here is that it's a decision for the committee to determine whether this would go forward. My own role has been to engage with members of different parties to identify whether there is a path forward for the bill, keeping in mind from inception that the Combating Hate Act was actually designed to address discrimination initially against religious communities who are being prevented from taking part in their communities of faith by virtue of attending their religious institutions, places of worship, or community centers designed for specific communities. My view is that we're entertaining different perspectives to figure out what path forward would allow us to make good on the campaign commitment we've made to those communities and to address combating hate more broadly. If we thought there would be amendments that would make it impossible for people to practice their religion, we wouldn't support them. That would be antithetical to the very purpose of the bill. Should there be an opportunity to protect the bill and see its rapid adoption into Canadian law, we'll entertain potential amendments, but this is going to be a decision that members of the committee take.
When it comes specifically to your role in finding a path forward, as you say, for this legislation, did you make a deal with the Bloc to support this amendment before speaking to the Prime Minister or his staff about it?
So I've had, maybe just let me shine a light on how we do our work. I engage routinely with critics from different parties, including the Bloc. I have engaged with the Bloc, including on this issue. We've been in lockstep with PMO. I've engaged personally with the Prime Minister. Our team has engaged with his team repeatedly over the last number of months, increasingly over the last number of weeks, including on this bill, including on potential amendments, not just on the religious exemption, but on a range of other items. We've had advanced discussions with the Bloc about potential pathways that could allow for the bill to be adopted, but keep in mind that the committee's process is not a decision for the minister or for the Prime Minister, it's a decision for the committee. So the deal that needs to be struck as between members of that committee. When I work with other parties, certainly I'll share information if I believe there's a path forward to protect the bill, which is a key campaign commitment that the government made. But when we go down this path, on major issues, certainly we deal directly with the Prime Minister where we need his input to make decisions. But when we're dealing with routine engagements with members of different parties or our own caucus, at a time when the Prime Minister, who's focused on defending the Canadian economy against the threats from the deteriorating trade relationship we've seen with the United States in particular, we don't necessarily knock on his door every time we have a phone call or a text exchange. So we've certainly engaged deeply. We've kept PMO and the Prime Minister personally informed along the way, and we have an opportunity as a Parliament to adopt this bill should the committee agree to one of a range of amendments.
But did you seek input specifically on this amendment before offering support for the bloc from the Prime Minister?
Yeah, routinely with his office, we've engaged on this issue, but not only on this issue, on a range of different possible amendments that have been put forward by different parties through the proceedings, some of which I've addressed openly in public, including during my committee appearance.
Next question.
Hi, Paula Tran from the Ottawa Citizen. My questions are for Minister Fraser. The staying of charges if delays reach or pass the Jordan ceilings are currently the biggest constraint requiring courts to deal with cases on time. I guess under this bill, how would you make sure cases won't be delayed excessively and that victims and communities aren't stuck in legal limbo for so long?
Yeah, this is a really important question. So first, we need to address the underlying challenge of delays in the criminal justice system. There's a range of things that the federal government can do. There's a range of things that provincial governments can do. For our part, we want to stay current with our judicial appointments to have the system continue to be able to deal with the volume that they see, and we've had major progress in that regard really over the last year and a half or so. At the same time, we're making changes in this bill that will streamline the process, including the regime through which evidence is adduced, in particular in sexual assault trials, which can eat up an enormous portion of time that could contribute to cases being dismissed for delays. But we had to ask ourselves the questions, do we think it's acceptable to leave the threat of a case being dismissed for delay, knowing the consequence would be the survivor of sexual violence may have their perpetrator go free despite having committed a crime in some instances. And where I've landed on this position is that I'm not comfortable with that consequence. We need to work with other levels of government who also have something to do with the administration of justice in their respective provinces and do what we can to address the systemic delays. But in the meantime, directing the courts to consider remedies other than a stay is something that will prevent that consequence of what I view to be a major injustice of having the perpetrator of violence go free without having their case come to its natural conclusion.
There was a report that was published last month highlighting how victims of gender-based violence and sexual assault are traumatized in the criminal justice system. I see you have some measures here that are trying to address this, but are you going to be implementing some of the recommendations that are in that report?
Just not having the report in front of me to cross-reference with the changes to the Victims' Bill of Rights, we're happy to undertake to provide that to you if it's useful. But I completely accept the point that you're making, and let me cite a couple of examples. Going through the process of, forget the criminal trial as a standalone issue, but reporting a sexual assault to anyone can be a deeply traumatic and embarrassing experience. Reporting it to the police, who may not believe you, who may give you reasons to walk away from the notion that you should proceed with seeking to have the system lay charges against the perpetrator, is a routine experience that women face in this country. You're often dealing with people who are not trauma-informed, who don't have appropriate training, and if you're handed off to a Crown prosecutor, sometimes it feels like they're more interested in the process than the actual victim of the crime. Once again, you have to re-explain your story to a new person, which can in itself be traumatizing. Then you can imagine showing up in court, having to tell your story again, sometimes in front of the perpetrator, who you're seeking to have held to justice. You'll be cross-examined routinely. What we're seeking to do is build certain protections into the process for victims through the changes to the Victims' Bill of Rights, including making sure people know to which information they are entitled. If they need testimonial aids, making sure that they have access to them to improve their experience when it comes to giving their version of events as part of the criminal justice process. Making sure that even after a conviction takes place during the parole proceedings, that you have an opportunity to have a say, both in terms of the victim impact, but also on decisions that will be taken by the correction system when it comes to moving a prisoner from one level of security prison to another. What we're trying to do is increase not only the ability of victims to take part, but to do it in a way that is sensitive to their experience, that reduces the personal traumatic experience they can have. I don't mean to suggest that after this legislation is adopted, the system will be perfect, but I can tell you some of these changes are going to have it be markedly improved.
Next question.
Hi, also for the Minister, Minister Fraser, to be clear. Kate McKenna from CBC News. First, I want to ask you about the bill. How does it still count as a mandatory minimum sentence if the judge has some discretion?
So this is important. What we've seen in the decisions that the Supreme Court has made that have struck down routinely each of the mandatory minimums is that there was no provision to recognize that there may be circumstances where the penalty would be grossly disproportionate, frankly, which in my view tend to exist when you're dealing with a set of facts that are probably outside of what an ordinary person would contemplate, given the nature of the crime that was the subject of the initial offense. The reality today is if you have a mandatory minimum on paper that has been struck down in some provinces or that will be struck down, is that you don't have a minimum penalty at all. So I would suggest that the existence of a penalty on paper that is not actually practiced in the system is not a real law people can rely upon, and it offers no value to people who are going through the criminal justice process. The court has directed in its decisions, or identified rather, potential solutions that could overcome the constitutional hurdle that they've identified. We've chosen to move forward accepting the court's identified solutions of creating some residual discretion, but only in those limited circumstances where the penalty would be grossly disproportionate to the facts on the ground. One thing that gave me comfort moving forward with this process is that we've seen Conservative members of Parliament implore members of all parties, including their own party, to adopt this kind of a solution. We've seen members of the Bloc Québécois advocate for this kind of a solution to restore mandatory minimums with some residual discretion of the court in those more extreme circumstances. So what we've done in the vast majority of circumstances is restore that mandatory minimum with some limited discretion that would allow the constitutionality of these provisions to survive their next challenge.
Great. And if I could just follow up on my colleague's question about C9. You just said you've certainly engaged deeply, kept the PMO and the Prime Minister personally informed along the way. Until yesterday, or possibly this morning, was the Prime Minister's office supportive of the block amendment that is set to be part of committee today?
Well, look, you can appreciate the conversations that the Prime Minister has with his ministers are typically private and confidential. But what we've been working on is to prioritize the actual bill. The commitment that we've made to communities across Canada was to establish new protections against hate crimes, including intimidation and obstruction, more recently through the consultation of that process, establishing the standalone crime of hate more broadly. And we wanted to ensure that there was a path forward in very close collaboration with PMO to ensuring that we have the adoption of that bill. Up until recently, we were examining different potential paths that would ensure that the bill would survive and be adopted by the committee and return back to the House. Those paths over time tend to narrow as you come to understand the positions of different parties. But again, it's important to recognize who actually holds the pen on these decisions. It's not me as the minister. It's not the Prime Minister. This is a decision of Parliament now, represented in a minority Parliament by members from different parties. So we are continually looking for pathways for all of our bills, including the Combating Hate Act, to actually make it through the parliamentary process, and we'll entertain different proposals from different parties, including the religious exemption, depending on how proceedings play out in committee.
Next question.
From Mr. Fraser, Michael Couture with CTV News. On today's announcement, you have talked, and you just spoke actually, saying that you're looking forward to the support of all parties to get this passed expeditiously. The last time an online harms bill was proposed, it started in 2019, and it had a very difficult road. What assurances do you have that you will get support from opposition on this?
This has come up on a number of occasions, first in respect to the Combating Hate Act, now today on the Protecting Victims Act. This is a different Parliament with a different government and a different Prime Minister, and we are not talking about the Online Harms Act as it existed in the previous Parliament under the previous government. There are certain problems in society that we want to solve that were common to the understanding of the government at the time. And some of those problems touch on criminal behavior that targets children in an online environment and, frankly, in the real world. This particular bill doesn't have crossover with the former Online Harms Act in respect of regulating online platforms more broadly. It has some limited impact on the mandatory reporting of those who know that their networks are hosting illicit information. But that is a very different thing than the regime that was being discussed under former Bill C-63. Similarly, the standalone crime of hate in a previous piece of legislation is something that's common to a piece of legislation now. But we are not copying and pasting legislation that existed from the previous parliament into this parliament. We are engaging directly with folks who actually know how to solve the problems that we're trying to address. That's the justification for seeing some of the measures when it comes to the criminalization of the distribution of AI deepfakes, for example, when it comes to the threatened distribution of child sexual abuse and exploitation material. We're trying to develop these measures not to mirror some previous piece of legislation that didn't make it through the process, but instead to solve problems based on the advice of experts in their fields.
Just as a follow-up, during the background briefing, officials said to reporters that Canada's goal is to eliminate gender-based violence. Is there a suggestion that this bill can actually do that?
If you set your goal as something less than ending gender-based violence, you're failing from inception. We can't tolerate some violence against women. I don't think it's fair or reasonable to accept that women in my life are more likely to face sexual violence than I am. I don't think it's fair that kids, increasingly in an online environment, are being targeted by predators. But we can't assume that these problems are going to address themselves by some coincidence. We have to do something about it. These measures are going to help, but I don't want to be understood to suggest that one piece of criminal legislation or even exclusively a criminal response, Mike, is going to solve the problem altogether. We need a whole society of approach. And this is true not just of this bill, not just of gender-based violence. This is true about public safety more broadly. Every time that I've introduced legislation, I've walked people through the elements of our strategy, which includes certainly stronger criminal laws, but investments in the front line, law enforcement, border officers, community organizations that are supporting women fleeing gender-based violence. But most importantly, if we're going to end violence and gender-based violence, we need to make those upstream supports. We need to make sure we have transitional housing for women who are fleeing violence now and affordable housing that's built for families on the back end. We need to make sure that we're actually supporting organizations that are helping develop healthy young men who are prone to commit violence against women in the future. We need to ensure that we're dealing with serious challenges when it comes to mental health and addictions that cause people to become violent. There is no silver bullet here. But if we look at the advice of experts who've committed their lives and careers to understanding these problems, who already know what many of the solutions are, we can make a hell of a difference, and we're committed to doing that.
Last question.
Rémi Autier, CIPAC. Ma question pour le ministre, mais si quelqu'un d'autre veut répondre en français, je comprendrai. Là, mais ma première question, c'est le projet de loi impose plusieurs obligations aux tribunaux qui sont gérés par les provinces, mais il n'y a pas d'argent pour leur venir en aide. On reconnaît des droits aux victimes qui vont devoir être respectés par l'ensemble de l'établissement juridique. Comment est-ce que vous allez épauler les provinces en leur transférant ces responsabilités?
OK, je pense que je comprends la question. Si je donne une autre réponse, c'est OK de continuer la conversation. J'ai beaucoup de conversations avec mes homologues qui représentaient l'intérêt des provinces et territoires. Il n'y a pas un exemple dans les provinces avec une ministre qui a posé les changements sur l'enjeu du délai. C'est inacceptable dans chaque province pour des cas disparus après quelques mois, parce que ce n'est pas justice. Il y a des responsabilités fédérales pour faire des appointements de les juges dans la Cour supérieure, pour ajuster les règles pour l'introduction de l'évidence. Mais en même temps, il y a des responsabilités de les provinces et territoires pour l'administration de justice dans leur juridiction. C'est possible pour identifier les enjeux pour la collaboration, pour exemple, la façon que nous partageons l'information sur le système de justice. Mais quand les provinces m'appellent et me disent nous avons besoin d'adresser le problème de la délai, il est raisonnable pour moi de faire une assumption. La province veut augmenter les investissements pour avancer la solution. Au même temps, le gouvernement fédéral a adressé les défis dans les compétences du gouvernement fédéral.
Et ma question de suivi concerne les peines minimales obligatoires. Vous les réinstaurez, mais en mettant une porte de sortie. Elle n'est plus obligatoire, donc, cette peine minimale, si un juge n'a pas à la respecter. Et vous avez dit plus tôt, bien, s'il n'y a pas de règles, on ne trouve pas ça mieux. Mais si le juge peut en faire à sa tête, sans balise, j'ai pas cru comprendre qu'il n'y avait pas vraiment de balise, le juge peut faire ce qu'il veut, donc c'est pas mieux.
J'ai une perspective différente parce que nous créerons une limite très spécifique qui réfléchit les mots dans les décisions de la Cour suprême du Canada. En particulier, je cherche le bon mot en français, en anglais, grossly disproportionate. C'est juste dans les situations extrêmement rares pour le Cour d'éviter les peines minimales. Et nous avons besoin de récogniser maintenant, quand les peines minimales ont disparu après une décision de la Cour, il n'existe pas. Ce n'est pas une réelle protection après une décision de la Cour éviter le fait de la provision. Avec les changements aujourd'hui, c'est possible pour le Cour de restaurer les peines minimales et en même temps, nous recognissons les discours dans la Chambre des communes avec les partis conservateurs qui soutenaient cette approche, les discours les députés de la Bloc qui soutenaient cette approche. Je pense que c'est possible pour restaurer des peines minimales qui ont disparu et en même temps protéger des autres peines minimales qui existent dans le Code maintenant. C'est OK? OK.
Thank you. This concludes the press conference.
Okay. Thanks so much, everyone.